morning.
SJC-12090, Commonwealth versus Castano.
Ms. Caddick, good morning.
Good morning. May it please the court, Elizabeth Caddick for Franklin Castano. In this case, Mr. Castano had been arrested, been read Miranda, and invoked his right to counsel. Nonetheless, about 6 hours later, the police asked him where the gun was located. It had been, by the time he arrived at the police station, it had been about 10 hours since the shooting had been committed. During that time, he had driven from Peabody to Lynn to meet up with his friends, who he then went to the police station with to turn himself in. In Quarles, the United States Supreme Court had said that when someone is immediately arrested and there's an emergency situation because the safety of either the police or the public is at stake, the police are excused from first reading the defendant his Miranda rights before the defendant is questioned about where the location of the gun was. It was an immediate threat, and it
Well,
was...
counsel, do they say they excuse them, or do they say that the statements can come in, that it's not a violation of Miranda? It's not an excuse for not reading Miranda, is it?
It's an emergency
An
exception.
emergency exception.
Exactly.
In this case, was the invocation of right to counsel, that was a Fifth Amendment invocation,
Yes.
correct?
Right, yes, it was his Fifth Amendment right to counsel, exactly. And of course, that's the right to counsel recognized by Miranda.
Right.
And by the U.S. Supreme Court in Edwards v. Arizona. They said that the invocation of the right to counsel is a significant event. So this significant event happened. There was no emergency because, as I explained, it had been
Well, is Quarles based on emergency, or is it based on public safety?
well, it said emergency, in that it was an immediate need to question. So it does talk about an emergency. And the U.S. Supreme Court has never extended Quarles to a situation like this, where someone has actually invoked the right to counsel.
But what did the police know at the time that he was asked, where's the gun?
All they knew is that his friend had told the police that Mr. Castano said, I threw the gun away. That's all they knew. They didn't know when, they didn't know where. And again, because 10 hours...
So had they found the body yet at that time?
Yes, they...
Okay, so they had found the body, so they knew the killing had occurred some period before. Did Garcia tell them when he had first spoken to him? I mean, how much did they know as the time that had elapsed?
Well, I don't know from the record that Garcia had told them that Mr. Castano had initially contacted him around 10 p.m. the night before. We don't know that. What we do know is simply that he told them that, or actually I should say, I don't know, it could be in the record. That wasn't something I had been paying attention to in the motion to suppress, whether they knew the length of time. But certainly by the time they questioned Mr. Castano, they had found Ms. Paulino's body in the morning, soon after he had turned himself into the police at around 9:30 in the morning. And then they questioned him around 2:33, so it had been 5 to 6 hours since they had confirmed that there had been the killing.
So 9:30 they find the body.
Yes.
And Garcia comes into the police station with him before 9:30.
Yeah, yes.
So how much before 9:30?
Well, I'm saying 9:30 because I believe I think the timeline was he got to Mr. Garcia's at around 9 a.m. They got to the Lynn Police Department around 9:30. They immediately gave the information about how he had killed Ms. Paulino. They immediately went to the apartment for a well-being check and discovered her body. So I believe there is in the Commonwealth's appendix a log of who showed up at the victim's apartment. It was,
And when they found her, she was in rigor mortis?
yes,
So they should have known that she had been dead for some period of time.
yes, that's true.
What difference does that actually make in the analysis of whether the gun is a public safety risk?
Well, in the way this court has addressed quarrels, in the cases cited in the defendant's brief, they are emergency situations where someone either had just used a gun or they see that someone has, say, a full cartridge for a weapon, and so it's reasonable to presume that right then the police officer is in danger of a gun, so they could
So
ask.
your definition of emergency is very time-intensive?
Yes.
Is that it? It's not something that can be prolonged over a period of time or proportional to the danger?
It's possible that there would be a situation where as soon as the police learn of it, they, perhaps someone said, oh, I left it in the bathroom at a junior high on Friday afternoon, and now it's 8 a.m. Monday morning. Yes, it's been, over 48 hours, but there's an immediate danger that
So-
adolescents might obtain.
So do I
it.
understand that you're arguing essentially that the findings made by the lower court judge were clearly erroneous because she found, or he found, that that the police officers knew more about the location of where the gun was discarded? Is that correct?
No, well, actually, what I argued is that it was an error of law. She did, or he did get correct that the police did not know the exact location. What the lower court judge said, it was reasonable to presume that he threw it away as he was driving out of the apartment complex, and that's unreasonable. I believe, I would argue that's objectively unreasonable.
Did the police, I don't recall, but did the police ask any questions other than, after the invocation, did they ask any questions other than where the gun was, about the gun, anything other than about the gun?
Well, initially, when he was still at the Lynn Police Department, when he was in the interview room after the third time, he was given his Miranda rights, and he did invoke the right to counsel. There were 3 detectives there. One was translating, and one of the 3 detectives kept asking Mr. Castano, well, so now tell us, why did you come in again? And what did you think you did? What is it that you said downstairs? And one of the other detectives says, well, he did invoke his right to counsel and really cut off the other detective. The Commonwealth immediately conceded that the answers to those questions were not admissible. Now, they were the Lynn Police. So we're talking about it's the Peabody Police Department, although it was the Lynn Police Department who contacted the Peabody Police Department and said, we just spoke to his friend, and his friend said he threw away the gun. Why don't you ask him where the gun is? And that happened in the afternoon. So, really, whether good or bad, the subjective intentions of the police officers aren't relevant. There's certainly no argument that they were being deceptive or they were trying to get any additional.
Well, the exclusionary rule is to deter improper police conduct.
Well, according to whether you can allow in the statement, or whether you can ask the question and then, allow in the statement, is if it's objectively reasonable for the police to assume that there is an immediate danger to the public.
Why isn't there an immediate danger if the gun hasn't been found? You're saying it has to do with the time lapse, but if the gun's out there, it's still out there, it's still a danger.
Okay, well, certainly the time alone isn't it, because as I said, you could think of examples where it's been a while, but then there's an immediate danger. But if all that is necessary for someone to violate, for the police to violate a suspect's asserted right to Fifth Amendment counsel, is to know that there had been a gun used in the crime and now he doesn't have the gun on him, then anyone who's arrested for an offense that involved a firearm could have his Miranda rights violated by police questioning.
Although in this case, he said he threw it away, so we know it was out there somewhere as opposed to.
Somewhere, and you,
And didn't Mr. Garcia say that he had thrown it away?
yes.
So he had already said that.
Right, but thrown it away in a dumpster, thrown it away in where he lived.
So if I'm not mistaken, what you seem to be saying is the police didn't do anything unreasonable here from a subjective point of view. You can understand why they did what they did. They're not ill-motivated or anything.
Right.
But in circumstances where there's a post-Miranda invocation of counsel, even though the police are not doing anything that's sort of shocking by saying, oh my God, where is this gun? We're going to go look for it. Talk to me about that. We should still suppress it, nonetheless, in those situations, even though it doesn't seem like the kind of thing that is so blameworthy that we would ordinarily use the exclusionary rule to preclude in the future. So you're not trying to do it to preclude this in the future, I guess is what I'm saying.
Right, there are a couple of answers to that. One is that in this particular case, you could even say that it wasn't terribly horrible what they did because he had already said he used a gun, to kill the victim.
And they didn't find a gun.
Right, but the other thing is I'm not just arguing, there are a couple of sub-arguments. I'm not just arguing that there wasn't an emergency here, and so even if this court were to adopt the rule that the quarrels exception applies to post-invocation questioning, I'm saying that this court should not even adopt that as a rule. The U.S. Supreme Court hasn't adopted it, so you don't have to follow it based on the U.S. Constitution. But when you look at the Massachusetts Constitution Declaration of Rights, this court has given, the state has given suspects, defendants, greater protection to the right to counsel and the Fifth Amendment right to counsel or 12th Amendment right to counsel than the U.S. Courts have. And so I'm arguing that there's a difference between questioning someone before they've invoked their Miranda rights, because you don't know whether they will invoke them, you haven't actually given it, to when someone actually invokes their constitutional rights. They've invoked the constitutional rights. Now, of course, not arguing that if there really is an emergency, of course the police can ask information that will neutralize that emergency, find out where the firearm is and get it. It's just that it can't be used against the defendant at trial in the Commonwealth's direct case.
Is there any case anywhere that has expanded quarrels to include the search for a gun where there was no specific reason to think it was in a place where children or other individuals may misuse it? Or it may be used against the police themselves?
There, I don't know if this is going to answer your question, there are 3 circuits, U.S. circuit courts, that have ruled that the quarrels exception applies to post-invocation.
No, I'm not referring to
no.
the Edwards issue. Put aside the Edwards
sorry.
issue.
Yeah.
Most of the cases that I'm aware of, there is reason to believe that the gun is in a place where a child may get it or where it could be used against the police officers involved in making the arrest. That was quarrels at the supermarket. Is there any case in which the police had no clue where the gun was? All that they knew was that it had been discarded, but they did not know where or when it had been discarded?
No, when I think of the cases that this court has followed the quarrels, it's immediate. Or either they immediately know that someone has a gun, like the juvenile cases where the kid takes a gun and runs away, and the father calls and says, "My kid just ran away with a loaded gun," so they know that they possess the gun then, or immediately beforehand. In one case, this court found that even though the officer didn't know that there was a gun, what he saw was a loaded clip in a glove box. He was the sole officer at a traffic stop of 4 people at nighttime. And under those circumstances, he had an objectively reasonable belief that he was in danger. So perhaps ammunition. There was another case, another juvenile case where the boy had brought ammunition, a huge bag of ammunition to junior high and was showing it to his friends, and this court said it was okay for the police to say, "Where's the gun?" And in fact, the gun was just outside the school grounds.
Can you address how this affects the evidence in the case and whether there's a substantial likelihood of a miscarriage of justice as a result, if assuming that there's error?
Well, I would say that right, I would say that the standard of review is whether it was harmless beyond a reasonable doubt.
Okay.
And so because of that very difficult standard, I would say that there was prejudice. The defense was that it was accidental and that Mr. Castano turned himself in because he was feeling remorse and guilt. What the Commonwealth did with this was to bring out from the police that they had at least a dozen police officers at any given time spending 4 hours looking for the gun. They had help from Danvers, Salem, Peabody Police looking for it. They used a backloader to remove the snowbanks, to dump the snow somewhere and painstakingly go through to look for the gun. They had a sniff dog. And then the Commonwealth argued that he played the police. He manipulated them. He lied to them that the gun was there, sent them on a wild goose chase. So instead of the defense being that this was someone who committed an accidental killing and was contrite, and instead it was argued that he was a manipulative liar. And so because the standard of review is harmless beyond a reasonable doubt, I would say that there was prejudice based on that standard.
If we could turn to the state of mind evidence.
Yes. In this case,
Why is the presence of the suitcases not sufficient to permit a finding that she had told the defendant that she was leaving him?
well, circumstantial evidence is allowed in proving that the defendant knew of the victim's state of mind. But there's not enough. What the trial court had said, what was enough is that there was a suitcase on the floor in one room that also had men's clothing. Well, the apartment was a one-bedroom, so the fact that there was a suitcase and clothing in one room doesn't really say anything. The suitcase wasn't packed. There was nothing like in the
There also a suitcase in the car, in his car?
an empty suitcase in his car. Yeah. But what
Saying it means nothing, but it could mean something.
well, but it's not enough to show. I mean, what we're talking about is the violation of his right to confront witnesses. So what you've got is
Who could he not confront?
he could not confront the statements by the victim.
Right.
So
Well,
what-
that's kind of not a good argument, is it?
right, and in order to allow his right to confront witnesses to be admissible, or for evidence to be admissible, even though it violates his right to confront witnesses, it has to be, of course, it's state of mind evidence, but because it's used to argue motive, it's used to argue, well, he had a motive to kill her, what you need to have some evidence that he knew that he actually had a motive.
What about the gifts?
That doesn't show that, it doesn't, first of all we know is that she had gifts from him, that those were viewed by the friend, and we have Ms. Paulino's words that she said she was breaking up with him and he gave her gifts anyway. That evidence just comes from her statements. That's not enough to prove.
Well, it's not enough because it doesn't come in for its truth.
But it's not. But the requirement that the defendant know that the victim's state of mind has to be proved by independent evidence other than the victim's statement. So the victim can't
It has
say.
to be proved by admissible evidence, but the problem is not that the problem is that the judge properly instructs the jury that you can't take what she said for its truth. You can merely take it for what the The fact that she said it, and that's an expression of her, the fact that she said, I refused to take a gift from him, or I gave back the gift from him, it would be offered for its truth if you were to say that that happened.
And the problem isn't the words of the victim saying that I intended to leave him, I didn't want these gifts, I told him I was leaving. It's that there wasn't enough evidence that he knew. And I'd just like to just say that, in fact, the requirement that the court tell the jury that they could only consider those words if they found that they were communicated somehow to Mr. Castano, that portion of the instruction was left out in the final instruction.
Have we said that the judge has to instruct, or is that it goes to the admissibility of it in the first place?
Well, I disagree with the Commonwealth that it just goes to the admissibility. This court in Commonwealth versus Lowe, L-O-W-E, had said that the judge properly instructed the jury and included the fact that the defendant has to know, and in fact found that that was mitigating for whatever other improper evidence was admitted in that case.
Okay, thank you.
May it please the court, Marcia Slingerland for the Commonwealth. This court has recognized and applied the public safety exception to the Miranda exclusionary rule, and that rule is premised on the idea that where there is an objectively reasonable need to protect the police or the public from any immediate danger associated with a weapon, the prophylactic rules of Miranda can be dispensed with to allow the police to do what they need to do.
Have we ever applied it in a context in which there was no information to indicate that it was in a place where children was going to be, or was going to be in a place where it could do immediate harm to the officers?
Where there was no information,
Well,
just,
all you had here was that he threw away the gun, correct?
that's right, when they asked him. But that was the whole purpose of the question, I guess, because they knew there was a missing gun. They knew
I know, they knew he was missing gun.
Yep.
So that's all they knew, though.
But they knew that the apartment complex was right across the street from a busy suburban mall, as the judge found, and it was a place where children frequented the area. In fact, there were kids that lived in the apartment complex, and so the police became concerned about this busy place.
Basis, people throw away guns, they could drive away, or they could dump it into there are a million places. What's the objective reason to think that the place he threw it away was a place that was going to be in a mall, as opposed to throwing it in a dumpster, throwing it?
Well, they did search in the dumpster, actually. They searched everywhere. They had to begin someplace, I think, and so they had to look.
I mean, but in the majority of murder cases we get, they throw away the gun. So you're saying in every murder case where somebody invokes Edwards, and we know that they threw away the gun, that they can essentially, although he's invoked his right to counsel, they can say, okay, I know you've invoked your right to counsel, but now I'm going to ask you, where is the gun?
I'm not saying every case. There has to be that objectively reasonable
And
belief.
so what is it about this case which separates it from every other case in which we know that somebody threw away a gun?
It's out in the public. It's not confined to an apartment building. For example, like the federal cases I cited where the federal courts of appeals have extended the rule. There are a couple of the cases where the Mobley case, the police weren't allowed to question because the defendant was secured. He's being let out of the apartment. They're going to get a search warrant. So there was not an objectively reasonable need to question in that case. So that's what will define when the police.
Well, while
can
you're
ask.
answering the chief's question, can you give us a sense of the quarrel's timeline and the geography involved in here? When was the murder? And just take us from soup to nuts, from when the murder happened to when he shows up at the police station and where physically he was, so we can get a sense of where he may have tossed the gun and when.
I think it's about 10:30 at night. He begins his commute.
I assume the question is based on what they knew at the time the question was asked.
Yeah.
Right, so based on what the police knew when they asked the question, where's the gun?
Okay. I guess that's a little different.
Maybe
but
different.
What the police, the defendant presents himself at 9:05 to the Lynn Police Department. Garcia tells the Lynn Police he killed his wife.
This is 9:05 a.m.
9:05. He is given his Miranda warnings twice. He's then taken to the interview room where a state police trooper is brought in to question him. That's at 10:18. And there is a video of this interview in the record that shows the questioning during this interview. At 10:28, it's noted that, well, that's when the interview ends. Shortly after the interview begins, he invokes his right to counsel. So the interview ends at 10:28. The Peabody detective who was present at the interview then asks Garcia, do you know what he did with the gun? And Garcia tells him, he told my wife that he discarded the weapon. So at that point, the Peabody police are responding to the home at 50 Keys Drive. Detective Lane has gone there and has seen the body, realizes there's a gunshot wound to the head, discharge casings. At the same time, the defendant is being brought to the Peabody police station, and his interpreter is brought also to the Peabody police station at a different time. Peabody officer Saya says that the defendant has been in his custody for 20 to 30 minutes when he asks that question about the location of the gun. And the Miranda warnings are given to the defendant in Peabody at about 1:50 p.m. So that's the timeline. It's apparent from some of the testimony at the motion to suppress that the police are busy looking for this gun while the sequence of events is occurring, and they can't find it. So they are concerned at this point, knowing where the
They're looking for the gun in the apartment?
No. I think when there were a number of people who responded to the apartment, no gun was found.
Okay.
So then they started going out and looking in that area, up and down the roads. And so because they couldn't find that gun, reasonably, they said, there's somebody who knows where that gun is, and we need to ask him. And the Peabody police didn't question him about the incident, what led to the killing. They only asked about the gun.
Did they ask where the gun was twice, 2 different times?
Yes, they did. Officer Saya did first, after he had booked him. And then, while the officers are out looking, Detective Lane comes back about 3:30 in the afternoon and asks the defendant if he would join her and help them locate the gun. And he agrees to do so, and the judge found he was 100% cooperative.
So, and as far as the geography goes, we know this was an apartment complex, and Judge Feely made particular findings about a daycare in a mall and the like, and we have lots of maps in the record.
Those were introduced at trial, not at the suppression
Not
hearing.
the suppression hearing.
So what did they know as to the time of death?
They didn't know, I don't believe, anything. At trial, it was developed through the testimony of
I'm
Garcia.
referring to at the time that the question was asked, what was known as to the time of death?
They knew that rigor mortis had set in, and so that she had been there for some time.
So they knew that there had been some substantial period of time between the killing and the time he walked into the police station.
I'm not sure I would say they knew there was substantial amount of time, but they knew there's a dead body and a missing gun, and I guess that was, and a gunshot wound to the head.
So tell us how this case could be cabined, or if at all, from the regular case that we've asked you about, where people toss weapons and police. If we say this was okay, are we going to be telling the world that it's okay to question people post-invocation whenever there's a gun involved? What makes this case different?
The location of where the killing occurred and what the police knew, I mean, the body, I mean, they as soon as they knew.
Would that apply to every urban area?
Here, there were children
No, but
present.
If there's any urban neighborhood, there are children present.
No, this is in the public, and it's not confined to a particular space where the police might be expected. There might not be an objectively reasonable need to ask that question. That's the key here. That's the linchpin, is was there an objectively reasonable need to question based on an immediate danger associated with a weapon? I'd say the immediate danger here is the area
Let's
near.
assume there is an emergency and that there's a good reason to ask for, where the location of the gun is. Why does that mean that that statement that he made post-invocation should be used at trial, should be allowed to be used at trial?
Based on the public safety exception that this court has accepted. And I'm relying on the federal courts of appeals cases and their reasoning that the public safety issue doesn't go away when a defendant invokes his right to counsel. And it's important here that the police did not question the defendant about anything about the case. They weren't seeking to interrogate him. They were seeking only to learn to neutralize this threat that they perceived.
Then they use that information against him at trial.
And the public safety exception to the Miranda exclusionary rule allows that. And this court has accepted the rationale that it's an exception to the exclusionary rule. I would point the court out to a law review article I found, 68 Rutgers University Law Review at 957. There are at pages, I think it's 993 to 995, the author has collected a lot of cases on quarrels. As you can imagine, there are hundreds of cases. It's a spring of 2016 case, and he specifically deals with this issue when there's an invocation of the right to counsel. And the cases, that he cites cases both ways. But when you look at the case, and I also would direct this court to the Cosby case. It's a Kansas case, which recognizes that courts go both ways on this issue. But when you look at the cases that suppress the evidence and don't allow it in, there's often some police coercion involved. There's often, for example, in the Zanini case, which is cited in the law review article cited by my sister, the police officer, the defendant became concerned about incriminating himself, and the police officer said, well, this is only for public safety. And so that was enough to suppress the evidence. So I'd suggest in many, if not most of the cases, if there's a suppression, there's something else going on. Here we have police who are acting solely to protect the public. They aren't seeking to use this against the defendant.
He did.
He did.
No,
Well,
he did.
that's how it...
Did. I mean, you could have basically just, you didn't need it. Why in God's name did you put it in?
It was put in because the gun was missing. Maybe the jury wanted to know.
You basically presented it to show, and then you should show that he had lied. You offered it solely to show that basically he was deceiving the police about that which you say was asked about public safety, a gun they never found, and then in closing argument, you say he led them on a wild goose chase, and he's leading essentially, this whole accident stuff is part of the same wild goose chase he's leading the police. I mean, there's nothing, if you wanted the gun, you could have looked for the gun and simply said, we're not going to use it at trial. So I understand that there may be a concern about it, but if you have the concern, then look for the gun. But then why risk an otherwise compelling case by throwing this stuff in? Where's the judgment there?
There was evidence that he had thrown the gun in another place. As he was driving to his friend's house, there was testimony that the gun was in another place, which allowed the argument that...
You had that testimony. You could have called a witness who said, he told me he tossed the gun.
Right. Well, if you decide it was error, I would suggest this was harmless beyond a reasonable doubt because of the overwhelming strength of this case. There is a contact gunshot wound to the temple of the victim, essentially negating the defense of accident as it was explained in this case. It just is overwhelming. You consider also...
Was this also a ligature? Is there a ligature also?
There was testimony by the medical examiner that, I forget her exact words, but it was suggestive to her when she considered the petechial hemorrhages in the victim's eyes, and the abrasions to her neck, and there was a very distinct mark on her neck from the necklace she was wearing. That was suggestive to her of the possibility of a ligature strangulation. That was argued in closing as being consistent with the position of the defendant when he shot the victim, because he would have been pulling, based on her position with her head turned to the right, and where the marks appeared on the victim's neck would be consistent with the defendant being right above her, pressing her against the couch when he shot her through the head. And that was essentially the import of the ligature evidence. However, no doubt the cause of death here was the gunshot wound to the head.
And there's no doubt that it was contact?
No doubt that it was contact. There are pictures in the supplemental record appendix, as well as the testimony of the medical examiner, that there was a ridge around the wound, and there was soot within the wound, and on the abrasion around the wound, indicating it was a contact wound, meaning it was held against her head.
Does the defendant in closing comment on this?
The defendant's closing?
Yes, on the physical evidence?
I'm sorry, I don't recall that.
Okay.
Let's focus more on the prosecutors.
Going back to the timeline, again, 10/28 is when Garcia said, he told my wife that he discarded the weapon.
It's sometime after it's sometime after that.
Okay, and was that before or after he invoked his right to counsel?
That's after.
After.
Yes.
And why is he being interviewed 3 times if he
No.
invoked his right to counsel?
No, I'm sorry. He's, the officer, the Peabody officer, Ritchie, is interviewing Garcia
Right.
about where the weapon might be, because they're not going to question him.
Right, that's what I'm trying to get a sense. Had the invocation of counsel occurred with the defendant before they learned that?
Yes, before they learned from Garcia where the gun was, yes.
Does it matter that it is Edwards? Does it may, I mean, I understand that if there is truly a public safety risk that may emerge at that time, you may be able to ask for it, but does it change our standard at all? Because now it's an Edwards violation, not merely a Miranda violation.
Well, Edwards, as well, is a prophylactic rule.
You say courts go both ways on that issue?
When there's been an invocation, yes. But I think when people say they go both ways, you have to look carefully at those cases that don't allow the evidence in, because I'd suggest usually there's something else.
But, well, there might be something else, but you cite 3 circuit court cases that say the public safety exception applies post-invocation, right?
That's right. It has to by nature, and it's defined by whether there's that objectively reasonable need to protect the police or public from any immediate danger. That's the linchpin of the case. If it doesn't fall within that, then it's excluded. It's not admissible. If it does fall within it, under those cases and the cases that allow it into evidence, then it comes into evidence.
Is it precisely the same standard, or is it maybe a even more demanding standard? Because generally I'm not going to give you Miranda first, I'm going to just ask you these questions. You haven't invoked any rights, we're just going to postpone giving you these rights. Here, he has invoked his rights. It's the strongest position for a defendant to be in. Does it matter in terms of how we evaluate public safety, or is it the same standard as it would be pre-Miranda?
My position would be, or our position would be, that it's the same standard under Quarles, because Quarles is really the essence of what's being looked at here. I mean, you're judging the police behavior, but you're doing it on balance with that public safety situation, whatever it may be. And if it's objectively reasonable, under that whole standard, then that's the end of the inquiry, would be my position.
So if there's a public safety exception, and we say that has to be objectively reasonable, and if it's objectively reasonable, then it's admissible, what's, and understanding the exclusionary rule, and it's to deter misconduct and all that, and there's no misconduct, how does the time frame or the proportionality or the scope of anything fit into that analysis at all in terms of admissibility? Or is it just not at all relevant?
I think it can be relevant. In this case, it's not, because you have a missing gun that's been used to kill somebody in an area that is very congested. I mean, there's a lot of testimony at the suppression hearing about what that area involves, and that's why the police were so concerned. So the time is not so significant. In this court's decision, Dillon D., there's no exact time limit specified, but this was a kid at school who showed his schoolmates the bullets. They sent him down and talked to him, and they wanted to, then his mother came down. She didn't get Miranda, so there's a Miranda violation. Then they hold a hearing to suspend the kid from school, and then they finally get to asking him where the gun is after he's been suspended from school. So there is some time that goes by there.
Let me ask you about a particular finding that was made by the motion judge. He wrote, "It was reasonable for police to believe that the firearm had been discarded in close proximity to Castano's apartment complex." Where does that come from?
I think a common sense interpretation of the situation facing the police. They had to begin looking somewhere, and they knew where the killing was.
Okay, so he shoots his spouse, we know that. He leaves, and he goes to his friend's house, right? And then the friend takes him to the police station.
Right.
But how is it reasonable to believe it was in close proximity to Castano's house when he left his apartment, and we don't know where he went before he showed up at his friend's house?
I guess I just say they had to start somewhere. They had to look for this gun.
But what they did is what they did. I mean, they had to look for the gun. I don't obviously fault the police for that, but I'm just trying to figure out how that's supported by the evidence.
Well, that was the purpose of the question. They were looking for it, and they weren't able to find it. And the cases, especially in this law review article, will support almost all courts. If you're looking for a gun that's missing apparently in public, it's not in the privacy of the apartment, it's out somewhere in public, that's the whole point of the question, is to help them find it.
Say in public, how do we know it's not in a garbage can? How do we know it's not in the river? How do we know it's not?
That's the purpose, I'd suggest, of the public safety exclusionary rule. In this case, it's particularly compelling because you have a firearm. You know, this isn't a question that has to do with, was there an accomplice or other.
We'd have to find that finding to be clearly erroneous, correct?
That's right. The state of mind, I guess I would rest on my brief on that issue. There are no further questions. I would rest on my brief.
Okay, thank you.
you.